Think about that. Consider it in formal terms, in terms of arrangements, in terms of the legal procedure, in terms of the design and how it should appear, the lethal injection, the medical, the delay, the distance, the privacy. Considered in formal terms, today's death penalty is a kind of negative mirror image of the public torture lynching. It's an inverse, a disavowal, calculated to deny any association. So the way we do it today is kind of designed not to look like these atrocious events. But substantively, in terms of distribution, in terms of occurrences, in terms of outcomes, many of the same social forces that previously prompted lynchings nowadays prompt capital punishment. Many of the same social functions that were performed by lynchings then are performed by capital punishment now. And many of the same political structures that allowed lynchings to occur, things like a weak state, federated authority, local politics, the lack of a professional developed criminal justice system that governs outcomes at the local level, these are the kind of things that determine capital punishment today. So let me take 2 minutes in conclusion to describe how that happened. Think about the inverse of lynching. Think about the negative mirror image. Today's capital punishment process, as I've described, is heavily proceduralized. It's legally regulated and it's federally controlled. All the things that lynching wasn't. The defendant's rights of due process are carefully upheld. Executions where they occur take place in private, at a great distance from the crime in time and space. They're explicitly non-violent, they're solicitous, dispassionate, careful to avoid unnecessary humiliation and degradation, obsessed with leaving the body intact. Bureaucratic procedures ensure that crowds, cruelty, ceremony are reduced to a minimum. The negative symmetry that this mirror image involves might lead people to suppose, and I indeed do suppose this, that the modern death penalty has been designed to be a kind of anti-lynching. And I think that that's what's happened. The modern American death penalty law has been forged over time by a series of struggles between the federal courts and primarily between federal courts and southern political elites whose too summary, too arbitrary, too racist processes have become the focus of constitutional litigation. And the modern system's contours have been marked out, have been developed iteratively in one case decision after another, by one state political official responding to the constitutional rules after the other. They've been marked out in an ongoing effort to eliminate persistent practices of racial violence and rough justice. If any of you know the law here, over the last 75 years, in one case after another, federal courts have intervened in southern state cases, typically where there's been a black defendant sentenced to death for an interracial crime. In the beginning, usually for rape offenses, latterly for murder offenses. So, from the Scottsboro Boys cases in the 1930s, to Justice Goldberg's landmark dissent in Rudolph versus Alabama in '63, to all the famous cases that most people have heard about, Furman versus Georgia, Gregg versus Georgia, McCluskey versus Kemp. In each of these cases, the constitutional history has been civil rights litigation alleging that southern courts, usually Georgian courts in the ones that have gone to the court, have engaged in mob or crowd-dominated or racist or cruel and unusual practices. And what the federal courts have done, usually, most of the time, not always, is have responded by insisting upon procedural reform. That's the very American way. And due process requirements. For the most part, the states have responded by folding these requirements into their process, while continuing, nevertheless, to enact, invoke, and execute the death penalty. As a result of this struggle, the modern death penalty has been cured of its most egregious defects and cruelties. It has been domesticated, bureaucratized, sanitized, and above all, legalized, and yet it hasn't been abolished. It survives, as you know, in 38 states and in the federal government. And in the period since 1976, it's enjoyed a practical expansion and political revival. In fact, if you think about this for a moment, and I will only take a moment to summarize this, in its substantive characteristics, in its distributive features, it has a lot in common with the lynchings that occurred, even though it does its best to disavow them. So it continues to be concentrated in the South. In fact, as Frank Zimring showed a couple of years ago, the states which execute most now are the ones which 100 years ago had most lynchings. It continues to be driven by local politics and by populist politicians. It continues to give a special place to the victim and victim impact statements. Racial hatreds and caste distinctions, together with the passions aroused by especially atrocious crimes, continue to give the system its energy, and its supporters still insist that the death penalty is too good for the worst of the worst, and that only death can sufficiently mark the enormity of their crimes. It continues, we should say, also to produce false allegations, think about the exonerated, and racialized outcomes. Moreover, the collective killing of hated criminals, or even just the assertion of the right to put them to death, remains one of the ways in which groups of people express their autonomy, invoke traditional local values, and assert their own political identity. As well, the death of a demonized criminal and the drama and the stories and the narratives and the newspapers it permits makes news, gives pleasure, produces a source of entertainment for casual onlookers. So, to conclude, with respect to America at least, we should not view capital punishment as a relationship between a sovereign state and a disobedient subject. We need to view it instead, or as well, as a matter of group relations, of relations between one group and another, involving conflicts of race, of class, of region, and of religion. We should think about it involving political pressures on state actors, of contests over state sovereignty, and above all, of strategic choices by political actors who are operating in the face of the electoral competition on one hand and the entertainment zone on the other. Now, these tensions and these conflicts between groups, political actors, are structured, and this is very important, by the distinctive American polity, by federalism, separation of powers, the investment of local police powers and local penal powers in county and state governments rather than national ones. These tensions that I've described are a generic feature of any democratic society, but they're played out here within the very distinctive structures of the American polity, within the very distinctive structures of group relations, and within the very distinctive history of American violence. So if we want to understand this peculiar institution, it's these structures and that history that we have to study and we have to understand. Thank you very much.